President Trump is back with another unhinged rant, and this time he has directly pointed towards his fellow Americans for being stupid and dysfunctional for allowing birthright citizenship. His comments came ahead of the highly anticipated Supreme Court hearing for his executive order to end birthright citizenship altogether. Let's hear from the president.
What might be a first step?
This next order relates to the definition of birthright citizenship under the 14th Amendment of the United States.
That's a good one. Birthright. That's a big one.
What about that one in the court? That one is likely to be passed.
Could be. We think we have good ground, but you could be right. I mean, you'll find out. It's ridiculous. We're the only country in the world that does this with birthright, as you know. And it's just absolutely ridiculous. But, you know, we'll see. We think we have very good ground.
Symmetrically, forcing the government to win everywhere while the plaintiffs can win anywhere. They invert the ordinary hierarchy of appellate review. They create the ongoing risk of conflicting judgments. They increase the pressures on this court's emergency docket. They create what Justice Powell described as repeated and essentially head-on confrontations between the life-tenured and representative branches of government. And they disrupt the Constitution's careful balancing of the separation of powers. I welcome the court's questions.
General Sauer, these universal injunctions, as you say, have proliferated over the last 3 decades or so. Would you discuss, though, the origins of universal injunctions? In particular, I'm interested in sort of historical analogs or the historical pedigree, particularly the Bill of Peace that was proffered by respondents.
Yes, Justice Thomas, as you, I think, first pointed out in your separate opinion in Trump against Hawaii, the Bill of Peace is something very distinct from a universal injunction. So the Bill of Peace involved a resolution of a small, discrete set of claims of a small, discrete group, and even more fundamentally, it was binding on the members of that class and those represented by the class. So it's much more analogous to a modern class action under Rule 23. And in fact, as we've argued in other cases, and as this court has described in opinions like Ortiz, the Bill of Peace evolved into and is directly developed into, so to speak, the modern class action that has all the same features of a Bill of Peace. So in the words of Chief Judge Sutton in the Sixth Circuit, the Bill of Peace, it was a domesticated animal that looks nothing like the dragon of a universal injunction.
I'm sorry. Here,
Go ahead.
Here, there's a discrete identified group on one issue. Does citizenship mean are you born in the territory of the United States, or does it mean are you loyal to someone else, which is your claim, or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace. The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
Your Honor, I'd say 3 things in response to that. First of all, our primary contention is that the citizenship clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time. But more fundamentally here, as to the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind absent class members. Here we have the asymmetry.
Well, here, class actions don't bind anyone who opts out. So class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among, all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can I ask you a question? Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide, but as this
we
court...
couldn't enforce it against universally, is your argument.
If there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And
So
that
is what
means
this court-
you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
not necessarily. There are
Or a class action?
a class action would be the way
Isn't
that,
that makes no sense whatsoever.
respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very different here.
No, we don't, because the argument here is that the president is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally.
He said birthright citizenship was not meant for people taking vacations to become permanent citizens of the United States of America and bringing their families with them all the time, laughing at the suckers that we are. Suckers was not the only words he felt was necessary. He also slammed America and its people for being stupid and dysfunctional. The United States of America is the only country in the world that does this. For what reason, nobody knows, but the drug cartels love it. We are, for the sake of being politically correct, a stupid country, but in actuality, this is the exact opposite of being politically correct. And it is yet another point that leads to the dysfunction of America, Donald Trump wrote on Truth Social. He continued, birthright citizenship is about the babies of slaves. As conclusive proof, the Civil War ended in 1865. The bill went to Congress less than a year later in 1866 and was passed shortly after that. He continued, it had nothing to do with illegal immigration for people wanting to scam our country from all parts of the world, which they have done for many years. It had to do with Civil War results and the babies of slaves who our politicians felt correctly needed protection. The U.S. president tried his best to present his case. He said, please explain this to the Supreme Court of the United States. Again, remember, the Civil War ended in 1865 and the bill goes to Congress in 1866. We didn't have people pouring into our country from all over South America and the rest of the world. It wasn't even a subject. What we had were the babies of slaves. Thank you for your attention to this matter. He concluded the lengthy rant with, good luck with this very important case. God bless the USA.